Good morning, gentlemen. You each will have 15 minutes to present your arguments to the court, and you, the appellant, may reserve up to 5 minutes for rebuttal if you so choose. Just let the court know. Thank you, gentlemen. You may proceed.
May it please the court. My name is Russell L. Paintiff Jr., and I am the appellate pro se. Before I begin, I had filed a motion earlier, and I was wondering if you've gotten...
We received it.
Okay. I have copies if you need it.
No, we have copies. Thank you. You just go ahead and proceed, and let the court know, though, if you would like to reserve some time.
Yeah, I would like to reserve 5 minutes for rebuttal.
That's fine.
Thank you. I'm here to ask the appellate court to reverse the trial court's decision and remand the matter for a new trial. I would like to continue my argument of violation of Civil Rule 60B-5, as I believe all the matters of law and circumstances were not addressed adequately in Judge Baczynski's judgment entry date October 30th, 2014. In further argument, additional points of my state of mental capacity to execute a settlement agreement, I offer the following points. According to the record, during the May 30th hearing, Mr. Kelly, counsel for the defendant, stated to court there was $200,000 in an IRA account, which was mostly accumulated during the course of the marriage. I had previously demonstrated to the court that approximately $64,000 was designated at a marital contribution. Mr. Kelly deceived the court in his statement that day to bias the court that most of the money was a marital asset and to make it appear that Ms. Eberwein was foregoing equitability. I did not recognize it at the time. The statement was fact untrue. If I were in my right frame of mind and not coerced to settle, I would have asked for more equitable position by dividing the $64,000 in half instead of allowing more than the full amount of the marital contribution to be dispersed. According to the record, Mr. Kelly told the court on May 30th hearing, Mrs. Paintiff is keeping a whole house full, garage full, barn full of personal property that the two of them have accumulated over the years, which is worth thousands and thousands of dollars. Page 8, line 16 of the transcript. Mr. Kelly knew that there had already been an agreement upon which distribution, execution of personal property prior to the May 30th hearing. Miss Eberwein had taken equal or greater valuable contacts from the home freely and without restriction when she vacated the marital home in 2012. Mr. Kelly said to deceive the trial court that day that I had an unfair distribution of personal property. I did not recognize a statement of deception or their efforts to the court that day otherwise. If I would have corrected the statement immediately. As stated during the July 17, 2014 hearing, on several occasions during the course of the hearing, my counsel had to remove me from the courthouse to try to regain my composure and behavior.
And are we going to find a reference to that in the record in the transcript? In other words, where the court says, for the record, husband is being removed from the courtroom.
Well, I'm sorry, I was removed from the courthouse.
Or removed from the courthouse.
Well, there was nobody present other than my attorney, so it wouldn't have been on record. However,
so we're not able to really review that if it's not in the record before us.
I see. As a result, I was unable to help guide my counsel throughout the course of the hearing by correcting statements that were being stated. I mean, I wasn't in the proper mind. There was falsehoods being said, and I didn't recognize them. I just didn't realize it. Judge Baczynski was presented on July 17th with medical documentation and personal testimony to warrant that I was not in control of my decision-making that day, and that I was under the influence and unable to make a rational decision as a result of medication and my PTSD.
And you submitted an affidavit to that effect?
Um,
Was that the sole, I mean, we'll look at the record,
mhm.
and we'll see what's in the record and what's not, but I'm just wondering, was there a doctor, I don't remember. Was there a doctor's
Originally,
statement?
prior to that, I was seeing a psychologist who actually referred me to a psychiatrist because of my PTSD, who put me on medications.
And do we know what those medications are?
Yes, that's in the record of the appeal.
But I guess my question to you is, was it solely your affidavit, or do you have a statement from your physician or your psychiatrist?
There is a diagnosis from the physician in there, medical
That
diagnosis.
you attached to your affidavit?
Yes.
Thank you.
At the minimum, I feel Judge Bazinski should have ordered a preliminary hearing, which would have been warranted to vet out any discrepancies that allow for full disclosure of all the issues. At minimum, since Judge Bazinski stated he was not present during the hearing, it would have been judicial prudent for the sake of medical argument to have allowed a separate hearing for mental capacity, given the large amount of prescription drugs ingested, as well as the effects of the coercion on my mental state with PTSD. In the transcript of the hearing, Judge Bazinski said, "How am I to know if people understand what's happening when we talk about it?" That's on page 8, line 12. He further states, "I ask them if they understand, if they have questions of me," all those kinds of things. Again, page 8, line 23. In Judge Bazinski's ruling, he stated that the settlement agreement is a contract. A breach of contract therefore occurred in which the court erred by not addressing the points of breach. Non-disclosure is essentially misrepresentation through silence. When somebody neglects to disclose an important fact about a deal, Ms. Eberwein had a duty to disclose the requested financial information in order for the contract to fully be understood prior to the execution of that contract. Her financial statements in the mandated deposition on May 24th, 2013 by the trial court, in which she refused to attend and in which the court did not enforce compliance, would have been material to any negotiations and the execution of a final settlement agreement. If a party to a contract specifically asks another party about a fact, whether it's material or non-material, that party has a duty to disclose the truth in the order for a contract to be enforceable. The behavior of Ms. Eberwein to not disclose financial statements, refusal to attend court-issued depositions, along with her intimate knowledge of my medical condition and long-term use of prescription drugs since my MVA, and led me to conclude that she had violated the clean hands doctrine and knowingly acted in bad faith. If we take the view that the settlement agreement is a contract and therefore should be guided by principles of contractual law, the trial court erred when it used coercion and intimidation upon me and my counsel on May 30th to create a contract. I want to stress to the court that it was not my intention at any time to become incapacitated. I was there for a trial. One minute I'm there for the trial, next thing I'm getting forced into settlement hearing, or a settlement. We tried that route, it did not work. Judge Kovac had set a trial time for 9 a.m. Judge Kovac did not show up to court till 11 a.m. I was there at a little past 8. So basically for 3 hours, I'm sitting on a bench, a hard bench. I was involved in an MVA accident. I have some cervical damage in my arm, and again, there was no intent. I was just flat hurting. And I understand that a divorce is a stressful time, but you take the time, somebody that you've been with, and as you're separating, that's stress. But then you stack on top of that coercion by a judge, or just to clear her docket, just to force a settlement. You can understand my state of mind. As stated previously in brief, my injury was aggravated by periods of sitting or standing. In addition to that, while I was out sitting, talking with my attorneys, the judge's bailiff continued to walk by and tell me to settle this case or the judge would not be happy. When Judge Kovac, prior to the trial commencing, told counsel present to settle or lifetime alimony would be awarded, and when Judge Kovac stated during the hearing we would flip for all personal property, regardless that all previous personal property was already addressed and not just the Hutch, then she abused her discretion. A trial judge may not effect a settlement through coercion, as referenced through Pro v. Smith.
And Mr. Paintiff, you are into your rebuttal time if you'd like to state that.
Okay. All right.
Thank you.
Thank you.
Good morning. May it please the court, Mr. Paintiff. My name is Tom Kelly. I represent Ms. Eberwein, formerly Mrs. Paintiff. I think it would be helpful, Your Honors, if we would just review the substantive chronology procedurally of the case. This case was settled by agreement, an in-court agreement on May 30th. That agreement was read into the record. It was confirmed by the testimony of both the parties. And at that hearing, as the record will reflect, Mr. Paintiff had two lawyers representing him, Mr. Kenneth Hurley and Ms. Rebecca Clark. Following the closure of that experience, the court ordered or directed the plaintiff's attorney, Mr. Hurley and Ms. Clark, to prepare the judgment entry. Before they could do so, they were terminated. I took it upon myself then to prepare the entry so as to avoid any further delay. That entry was approved by the trial court on July the 3rd, 2013. No timely appeal was taken from that decision. Mr. Paintiff then, through a third attorney, Attorney Lisa Hahn, filed a motion for relief from judgment in late January of 2014, some 6 months later. That motion was heard by Judge Basinski in July of 2014, and then in October of 2014, the judge issued his decision and his order denying the motion for relief. This appeal today is taken from the denial of that motion only. Mr. Paintiff, plainly, makes every conceivable effort to continue to attempt to appeal the trial court's ruling of July 3rd, which is not before you. What is before you is Judge Basinski's order from October of 2014.
Well, I understand what you're saying, but I guess we have not been able to review the record yet. But his 60B motion that he filed, did that allege any fraud? Because he seems to be arguing here today in his brief that things weren't disclosed to him financially, which would have been fraud.
Yes, Your Honor. Mr. Paintiff has alleged many things on many occasions, and it's at times difficult for me to follow what his allegations are.
I'm just asking what's in the actual motion for relief from judgment. The actual file. And we can look at that, but I just wanted this.
I'd have to pull it, but
okay.
As I recall it, Your Honor, it primarily relates to his argument that he had insufficient mental capacity by virtue of his voluntary ingestion of way too many prescription medications, and that he was therefore deprived of his mental faculties when he was arguably making the agreements that he made. But as Judge Basinski points out in his determination, which by the way is supported by the testimony in the record, which again we bootstrap back up the May 30th experience, Mr. Paintiff was very, very clear in his desire to argue for himself about a number of issues, including a hutch and an automobile during the in-court settlement discussions. Nothing in the record would support the proposition that he was deprived of any mental capacity at all. To that degree, we think that the entire thing is a charade, and it's been designed. His fourth lawyer, Mr. Razzo, in one of his final arguments, made the point that this was not buyer's remorse. We think that's exactly what it is, and that there is no other justification for delaying the finality of this experience. Ms. Eberwein has been waiting patiently, way too patiently, impatiently at times, for the resolution of this matter, particularly with regard to our ability to force the trial court to hear our motion to show cause on the failure of the plaintiff to pay the money that he was supposed to pay. The money that he agreed to pay, the money that was referenced in the May 30th judgment entry. Trial court, rightly I suppose, declines to hear the motion to show cause until this matter is resolved, on the theory that were you to find in Mr. Paintiff's favor, then our motion would be moot. We think that the correct standard of review here is abuse of discretion. When it comes to abuse of discretion, the burden's on the movement here, the appellant, to demonstrate. There is no demonstration, there is nothing in the record to support any contention that Judge Basinski abused his discretion. Quite the contrary. He bent over backwards to make it palatable for Mr. Paintiff, again, in that case represented by an attorney, Frank Razzo, to allow him the widest latitude in saying anything he wanted to say and to present whatever evidence he had. He did so.
You mean that there was a hearing on the 60B motion?
Yes, ma'am.
Okay.
Yes, ma'am. That's the July 2014 hearing. In that hearing, he was given wide latitude, and he failed to persuade the trial court of his point of view. Now, to that degree, trial court's findings, I think, are to be given some presumption of correctness at this level on an abuse of discretion standard of review. To that end, then, and we say that there is nothing in the record that supports this contention that he was incapacitated or that he failed to have every opportunity to make up his mind about what was right and what was fair and what was just. And quite the contrary, he says under oath all of those things are true. You know, you can read in the record there's a certain, I guess, reluctance on his part to go forward, with the original settlement agreement. But in the final analysis, having been given every opportunity to consult with both of his lawyers privately, off the record, he comes back on the record and says, absolutely, that's fair, that's just, and I wish to be divorced, according to those terms. And what we have here is, in fact, a classic case of buyer's remorse. We ask that you affirm the trial court on that basis.
Thank you. You have about 48 minutes left.
Well, Your Honors, this kind of exemplifies the problem that I have. Again, Mr. Kelly has made statements to you that are untrue. I have never fired one of my attorneys, not one. Even Mr. Razzo, who has been paid to represent me here today, who I have not been able to get my documents from, he's gone. Have even had an attorney contact him. That's another falsehood told by Mr. Kelly to you. 2, if you notice through this whole thing in my contention, I've contended, and with Judge Basinski, coercion. Mr. Kelly was privy to that coercion. He has never denied it once. Not once. If he says I wasn't coerced, and you don't think that involved my mental state, then why don't you? I was there. It didn't happen. Never once. Because he knows it happens. As far as Judge Basinski allowed me to go on, he asked me if there's anything I could add. All this was put on his record. This all involves my mental state at the time of the original hearing. He contends I argued 2 points. I argued 2 points when you're talking about the scheme of things were mute points. I mean, we're talking about a hutch and a dining room table that wasn't even that big a deal. Why I picked on that to go, I have no a vehicle that was barely even running, that has not been drove to this day. And he says I'm failure to pay her. I have contacted all of my attorneys, including myself, has contacted Mr. Kelly, trying to settle the house. Offered the money to settle the house. I had a loan set up, a personal loan, to give her the money of the house. Wouldn't answer. It's just falsehood upon falsehood upon falsehood.
Of course, we don't know any of that from the record.
Well, that's his intent.
Well, let's just stick to what we do know in the record and not attacking everybody else.
Since Judge Buzinski referred to this as a contract, then I think contractual law applies. I mean, that's in his decision. If you apply contractual law, any coercion, anything to that effect, voids the agreement. I am not asking to somehow take anything away from Ms. Paintiff. Put us back to square one. Nobody's injured. We get to fight it fairly. That's all I'm asking. Put us back to square one. Let us start over. There's no damage. That's all I have. Thank you, Your Honor.
Thank you. Thank you very much for your presentation. Thanks to both of you for your presentation to the court today. The court will take the matter under advisement and will issue a written opinion to both sides. And you can also check on our website where we release our opinions electronically.
Thank you very much.
Thank you.